Today we shall speak about Russian labor law and particularly about the process of employment. My name is Natalia Neverovskaya. I'm a lawyer and I'm a partner with an international law firm based in Russia. We have two offices in St. Petersburg and in Moscow. And if you need any further consultations or if you need to know more, please contact me. You can also contact the Academy of Open Education for further trainings and further education on Russian labor law. You can see the contacts in your monitor, so please be free to call us or to write us your messages. Our law firm is one of the oldest law firms in Russia, and we help many foreign investors. We provide different services in different fields, and especially we are strong in the field of labor law. Labor law includes different processes such as employment and dismissal of personnel. Dismissal may be carried on in different ways in Russia, for example, staff redundancy. We help our clients to prepare the in-house documents, in-house rules, job descriptions, labor agreements, and other documents. If a foreigner starts to work in Russia, sometimes foreigners prefer to have export contracts. And in this case, export contracts should not contradict Russian legislation, so we can help with this. In many companies, employees produce documents regarding motivation and a bonus system, and in case something happens and there is a dispute between the employer and the employee, we can help with labor dispute resolutions, and we also can help with dealing with trade unions in Russia. Russian labor law consists of labor code, other legislative acts, and especially it's very important to know that Russian labor law consists of the labor agreement, which the employer writes and prepares for the employees. And also Russian labor law consists of the in-house rules that the employer prepares for their employees. Every employee will bring documents for employment such as passport, labor book, or the extract from the special registry where all the working records are kept. Also, the employer needs to bring the pension insurance certificate to the employer. Sometimes diploma is needed for the employment in certain companies, for example, for doctors, lawyers, for civil servants, and so on. And sometimes, if, for example, we work with children or we work with some sensitive information, it's needed to obtain the document showing that a person has no criminal records. When we agree with the employee about working in the company, we need to agree about possibility of setting the period during which we shall try to find the answers for ourselves, whether we need to work with certain employee, and the employee will find the answers for himself, whether he wants to work with our company. This period is called the probatory period. Maximum probatory period is 3 months. In some cases, for example, when we hire top management, the probatory period may be set up to 6 months. And if we agree about the probatory period, because this is the agreement between the employer and the employee, so both parties need to check each other and to try to work with each other. So if we agree about the probatory period, then we need to implement these terms into the labor agreement. So the employer prepares certain documents from the side of the company. The model labor agreement, job description, which is very important also because in labor agreement we can set the name of the position of the employee, but job description will show the list of what exactly the employee must do in this work. Then we prepare in-house rules. The number of those documents is unlimited. So in-house rules is not just one document. It can be plenty of documents regarding different questions and different ways of work. For example, it can be provision on commercial secret, provision on business trips, provision on personal data protection, provision on compliance policy, provision on, let's say, employment or the process of hiring of employees. So all the operations in the company can be put on paper, and those documents normally are called provisions. In-house rules typically a provision on some kind of operation, for example, provision on business trips. Those provisions will be obligatory for the employees, so employees must read those provisions and must sign on acknowledgement of on those provisions. Normally, the agreement is made for indefinite period. Only in certain situations, the employer and the employee can agree about fixed-term labor agreement. For example, if we hire an employee for some project work, or for example, the work is connected with the some season, for example, season work. So in this case, we have to set the reason of making the fixed-term labor agreement, but we need to remember that fixed-term labor agreement may not exceed the period of 5 years. In Russia, the first and the main place of work for the employee is called the primary employment place. The employee is not limited to have a secondary employment with unlimited number of the employers. The employee may have also secondary employment with the same employer. So, for example, we can take employee to work in our company, and we can employ the employee in our company at his primary place of work, but employee will help somebody else to do another work, and it will be the secondary employment. So the employee will get one salary at his primary place of work and another salary for the secondary employment. If two employments are with the same employer, then we need to consider the working hours, and we need to consider the labor protection rules. If the employee works with another employer, we may not know about working hours of the employee, and this information may be unknown to the current employer. In Russia, it's possible to work distantly or remotely. If we hire the distant employee, then we have to set certain terms in the labor agreement. And for example, we need to agree with the employee about compensation for its own property used in case of distance or remote employment. If the employee works distantly, then employee maybe will use its own furniture or equipment, electricity, internet, and so on. So the amount of compensation must be set by the employer. If we employ a foreigner, we should remember about work permit, which should be received by the foreigner. I would like to thank you for your attention, and if you need to know more about labor law in Russia, you are welcome. Please call us or please send us an email. You can also contact the Academy of Open Education if you would like to obtain training courses, also in English language. So thank you and take care.